Welcome, everyone. And if you didn't hear that announcement, the meeting is now being recorded. And I'll start with a little introduction of what we're doing today and why we're here, although I think everyone knows that, who I am, and then I will briefly introduce DSL staff and then let them introduce themselves a little bit more in depth. And then I'll also provide background on a couple of people that are making sure we have notes taken in the background so you won't actually see them or hear from them. And then ask the group to do introductions of themselves as we go around. So as you are aware, the Department of State Lands is opening rulemaking, which is the process that allows us to either create new administrative rules or edit existing rules. And we're doing kind of a variant of both of those things. We had a set of rules, Division 125, that address special uses, and communication sites is such a complex entity in itself that we decided, besides just updating the rules and further clouding up the special use rules, that it warranted opening its own set of rules. So that's what we're here to do today. It started with the essence of what we had before, and we beefed it up quite a bit. And everybody here should have been provided copies of that, but we'll dive into that here shortly. So that's the purpose of this meeting. It's a RAC meeting, Rules Advisory Committee. There are a couple more potentially on the horizon, 2, maybe 3. We'll see how it goes. For today, after we do the introductions though, I'll have Amber present the agenda and what that's all about. So I'm actually going to go ahead and put a presentation up on the screen for you to look at, so you're not looking at just me. And if it looks like I'm glaring at you, I apologize. It turned out the lighting in here is really bad, so I have a LED light shining right in my face so you can actually see who I am. I promise I'm not glaring at you.
Chris, do we want to wait until after introductions to put the presentation up?
Sure, we can do that, Amber. With that, we'll go ahead and dive in though and introduce ourselves first, the Department of State Land staff. My name is Chris Parkins. I manage the Bend Field office. New to this position in this agency. I just came from 21 years with Oregon State Parks, but I'm very glad to be here. And I already knew most of the team before I came into this position. So it's been a real blessing for me. I'm happy to be here and happy to help people rip off the bandage and get these rules up to date. So we have a few more rule sets in the future that we'll be bringing up. So you may hear from us again once we put the bow on this. Just some rules that staff brought up are pretty outdated. So with that, that's who I am. Amber, since you already spoke, do you mind introducing yourself?
Hi, I'm Amber McKernan. I'm property manager with the Department of State Lands. I do special use leasing, access easements, and land sales and exchanges. And my territory is the east half of the state. So Harney and Malheur, and then all the way to the north to the Columbia.
Thank you for that introduction, Amber. I'll also add a couple of pub trivia facts for you to know about Amber. First of all, she's our lead property manager at the moment, and hence you will hear more from her today than most everybody else, but we'll go ahead and introduce the other staff that are here. Sheena, do you mind going next?
Sure, I'll wave so you guys can see who I am. You'll hear my voice coming through Chris, his little box, because we're sitting in the same room. So anyways, I'm Sheena. I'm actually a rangeland manager with the department. Some of you may know my name from dealing with me with communication sites last year, as I was on a job rotation last year. So I volunteered to help out with this project since I knew the program a little bit. So if you have any questions, feel free to ask me. And Sean, where are you at?
I am here.
Sean, you don't have to turn on your camera if you don't want. I'm going to say, here's my trivia fact about Sean. He's not feeling well, but we've been so looking forward to this that he's still here today. So thank you for that, Sean. Yeah. Do you mind explaining your role?
Yeah, absolutely. I'm a property manager. Much like Amber, do the same type of work that she does. I've worked at DSL for the last 15 years, dealt with communication sites a lot of that time, and I'm sure I've worked with many of the folks on the, or at least the organizations that are on this in this meeting. Yeah, look forward to working through this RAC and revising our rules and making it the best for us all.
Thank you, Sean. And thanks for showing up today, even when you weren't feeling well. I appreciate that. So a couple of staff are hiding behind the scenes. I'm not going to ask them to speak up, but just so you know, if you see their names on the roster, we have Lonnie, who's recording for us. You heard her by the push of the button that the meeting is now being recorded. We're just trying to make light work of this and divide the work out and make sure that all of our bases are covered. So we have note takers, recorders, everything else, so that we can have a free, productive conversation. I also would like to introduce Erin Sarah. She's behind the scenes as well. She's scribbling away madly, taking notes. So Erin is a ownership specialist, but today her specialty is that she has an eye for detail, so she can take really good notes. On that point, I would like to mention that we're going to kind of get into a flow here. Once we start getting some input and stuff, I'll be calling on people. There'll be times that you raise your hand. I would just like to ask that the first few times that you speak, to make sure and start with your name, just to help Erin get in the groove of who's talking. And she doesn't have to be watching the little icons on the screen. She can be scribbling away. And once she gets to know your voice, I'm sure you can quit introducing yourself each time. So with that, did I leave any DSLers out, Sheena? I think I covered everybody. All right, so I'm going to go ahead and go around the room here, so to speak, and ask people to introduce themselves. And let's just keep it brief. I'd like to touch on time real quick. As a number of you with sharp eyes noticed, the agenda allotted for about 2 hours of meeting time, but the invitation allowed for 3 hours of Zoom time. That was to put a buffer in there in case things are really going productively and people can stick around. But our goal is to try to make this bite-sized. This is a big piece of work for us. So we're shooting for 2 hours. Maybe we'll go a little over 2 hours. Hopefully we don't take 3 hours. That's to explain the discrepancy there. And with that, I'm going to go around here. Stephanie, you're the first one that I see, so I'm going to unmute you.
Stephanie Bowen, I'm the office manager here at Harney Electric Cooperative. We're located in Hines, Oregon. I handle the financial and compliance aspects of the cooperative. Our co-op serves about 1,200 members, over 20,000 square miles in Eastern Oregon and Northern Nevada, very rural. No cities to speak of in our territory, so just mostly farms and residences.
Stephanie, thank you for the background there. That was a very helpful introduction. And if everybody can kind of follow suit, that's what we're shooting for. And let's see, Steve, it looks like you're next. And also on that note, your icon or avatar shows you as Steve. If I call anybody by a name that's on their avatar and they really prefer to go by something else, please let us know and we will go by that. We want to be as informal or as formal as you prefer and respectful. Steve?
Fair enough. I'm Steve Quick. I'm the superintendent of schools of the Harney County School District number 3, which is essentially comprised of Hines and Burns here in Oregon. There are other rural school districts around us that Stephanie covers, but with ours is mostly just Hines and Burns.
Very good. Thank you, Steve. Glad that you're here today. And Lori, it looks like you're next on my screen. Do you mind going next? Let me see here if I can unmute you. You're still muted. Okay. Pointing down there. Sorry about that, Lori. I'm trying to figure this out.
That's okay. Am I off now? That's me.
There we go.
There.
We can hear you. Yep. Thank you.
I'm the Land and Realty Program Manager at Cow Creek Band of Umpqua Tribe of Indians. And we were awarded, returned Canyon Mountain, which has a bunch of leases and information stuff that I'm learning about. I've been in this position for 2 years, so it's all new to the tribe and me.
All right. Thank you very much, Lori. And Lori, I realize now that I actually have multiple icons for you. So I think because you're calling from a phone too. So
Yes, correct.
I'll try to account for that. With Lori's introduction, I'll use that as an opportunity to point out, hopefully you're all noticing there's kind of a theme here. The people that have been invited here have been handpicked as stakeholders in this particular rule set. So it wasn't a random drawing. we want you for your expertise. John, I'm going to try to unmute you here. Oops. Or you might have to unmute yourself.
I was kind of hoping for random drawing.
There are
My
better
name's John.
prizes to be had than a 3-hour meeting.
My name's John. I'm with Oregon Public Broadcasting. We have 87 sites across the state of Oregon and Southwest Washington, including remarkably only one, I believe, with the Department of State Lands, which we just closed a lease, and Sheena, Amber, and Chris just got the better of me in the negotiations. So maybe they just felt bad and decided I needed to be involved in the rulemaking, and blessed me with multiple 3-hour meetings. So while I don't think this will impact us for, I think, 20 years, I forget how long a term we negotiated. I'm happy to be here and to contribute in whatever way would be helpful.
Thank you, John. That's very helpful. And how about Chip O'Hearn?
Good afternoon, it's Chip, and I'm a real estate project manager for SmartLink, which is a national vendor to the wireless carriers. And I represent the area in land use and real estate within Southwest Washington and Oregon.
Thank you very much, Chip.
Thank you.
Travis, it looks like you're next.
Hi there, Travis Coleman with Lumen, CenturyLink. I've been in the industry quite some time. However, I have very little experience dealing with any land use issues or site acquisition. So it's kind of excited actually to be able to be part of this process here. I'm in the Portland area, but I have pretty much the entire state of Oregon and then the southern half of Washington as well.
All right, thank you very much. Appreciate that introduction. And Cassandra, there you are right there. I see Cassie, and I've heard you go by Cassie before, so I assume that's what I should address you as.
Yeah, hi. Cassie Rippey, Tribal Historic Preservation Officer for the Coquille Indian Tribe. I'm the Tribal Historic Preservation Officer and archaeologist. So I've addressing both tribal issues and cultural resources issues for this. I will be off camera today. I am also not well, so I'm just going to be off camera, and we'll try to join on camera next time.
I'm wondering if these meetings are having an effect on people here. So Gabriel did call in while everybody else was introducing themselves. So I see that his avatar says Gabe, so I'll go by Gabe until I hear otherwise. Gabe, we're just doing introductions around. We actually just started. You didn't miss anything. So if you don't mind telling us who you are and what you do, and we haven't even gone over the agenda or anything yet.
Yeah, sorry I'm late. I had a meeting that went over by about an hour. So I'm Gabe. I'm from the Oregon Department of Transportation Wireless Communications section. My position is I'm the wireless leasing and procurement coordinator. So some of the leases I take care of. I also have a colleague who is our realty coordinator specialist, I think is what her title is, who also deals with the leases in our section. So it's not just me. I work on a small team with a small team for our leases.
Very good. Thank you, Gabe. So the list of the other members was included in the packet you got, should have been, so you could see who everybody is. For clarification of what their roles are, but basically each one of them is a stakeholder somehow in the communications game. So with that, before we switch over to the agenda and put the presentation up on the screen, I just wanted to do a sound check with Erin, who again is our note taker, and make sure she's hearing us okay. Erin, you can either chime in or throw a thumbs up or something to let us know that you're hearing us.
I can hear you, but I don't think I'm going to type as fast as anybody is going to talk.
Bullet points. So thank you, Erin. And again, thank you for taking notes today. I really appreciate that. There are a few scribes today. Sheena will be scribing or scribbling away as we start to actually edit the rules, but Erin is essentially the meeting note taker. So thank you again, Erin. Again, a couple of folks are off camera. They've chosen to stay that way, and that's fine. So let's go ahead and dive in. I'm going to see if I can get our presentation up on the screen here. And then once we've done that, I'm going to let Amber go over the agenda. Give me just a second here. Oh yeah, thank you. All right. So hopefully everybody can see that. Should have opened it in a presentation view instead of as the PDF, but this will work. Okay. So this is just the cover page for the meeting. It reminds you of what we're here for and who your contacts are with the agency. And next, I'm just going to go ahead and scroll into the agenda page and let Amber give us an overview of the agenda.
Chris, can you zoom out a little bit on that?
You bet.
Seems like the slide isn't quite all on the page. Okay, so as far as what we're going to do today, we've gone through the welcome and introductions. After I go over the agenda, Chris is going to dive into the Zoom protocols for the meeting. And then he's also going to talk about the rulemaking process. After that, he'll go over the operating principles, which you guys all received in the email. So you should be familiar with that. I believe it's just going to be a quick overview. We've only got 5 minutes on the agenda for it, so you don't need to reread the whole thing again today. And then also talk about the importance of the RAC role and why you guys are here. After that, we'll talk about the purpose of the rulemaking, why we're doing it, and what we hope to accomplish through this rulemaking. Once we get through kind of that information dump, we'll take a quick break. And after that, we'll come back and start diving into the actual draft that hopefully you guys were able to review. And we'll start looking at specific sections of the rule draft, and we'll let people with comments bring them up as we go through each section. That's hopefully going to be the bulk of the meeting. It's got 50 minutes on the agenda. If we need to take longer, we'll definitely do that. We have the Zoom meeting scheduled for until 5 p.m. If we need to use that time, we will. And if we don't need to use it, if we've covered what we expect to cover, then we'll absolutely end the meeting when the productivity stops. So after we go through the draft rules and we've collected all the comments on the portions that we intend to cover today, we'll give a brief summary and next steps on what to expect next. And after that, the meeting will end.
Thank you very much, Amber. Before I slip into the meeting protocols, we've touched on it a few times already, and that's that, yes, the agenda reads about 2 hours, the Zoom meeting reads about 3 hours. We're not going to milk this out just to keep people at their screens for 3 hours. So that's not the point. The point is if it's productive and we go past 2, let's do it. If it's not productive or we've gotten to a line in the sand for what the next meeting will cover, we'll talk about it in more detail later. But for instance, we want to separate out meeting 2 to really get into the financial aspect. So by then we'll have produced some financial impact statements and data for you to review. And then that will be the meeting where we dive into the compensation aspect and the complexities of co-location. So those are both big topics. And that way we can just separate out a topic by each meeting. And I don't have to say this because everybody showed up today, but if somebody hadn't showed up today, part of the meeting protocol will be not rehashing something that you missed because you weren't at a meeting. With that, the expectation is if you're not going to make it to a meeting, that you can have somebody stand in for you. Just the idea is that somebody should be here representing your agency or company. So again, the meeting is being recorded. It is a matter of public record. That's the primary reason we record it, so we'll tuck it away. But we will be, again, taking notes as we go along, and everybody will get notes sometime reasonably shortly after the meeting. And so we'll all be working off the same information. Most of the Zoom meeting protocol has to do with transparency. It's about us speaking openly as if we were in this room together. If we were in this room together and somebody had a question, everybody would hear it. If DSL had to provide an answer, everybody would hear it. So we want to operate the same way. So with that, we have the chat window set up so that you can put up a chat question or chat comment. but those will be saved. We'll have Zoom transcribe those for us. And also everybody will be able to view them. So it'll be just like you're sitting here in the room. So keep that in mind if you ask a question in the chat. You don't have to use the chat. We're really hoping that things flow smoothly enough. You can just raise your hand. We'll call on you, get your question or comment, and everybody will have heard the same information. So the public was notified of this meeting. There will be an actual process later where the public can have input, but they could have joined in this meeting if they wanted to listen, but we would not be taking input from them, only from RAC members today. Be respectful of each other and how you address each other in the meeting. Please keep yourself on mute if you're not talking. And if you have a question or comment, again, just raise your hand. Put these up on the screen so you can see them. And I'll call on whoever has their hand up and allot time to ensure we get everybody in. So that's the condensed version of the Zoom meeting protocol. Does anybody have questions on that? I'm assuming by now, after a year and a half of COVID, you've done all types of virtual meeting platforms, and hopefully you've done at least 1 or 2 Zoom meetings. That's not the one we use most, so I may fumble a bit here and there myself, but that's what we're doing here. So now about the rulemaking process, this graphic here just highlights what the various steps are. Initial outreach, that's already been done. That included contacting potential RAC members and forming the RAC, that's step 2. So the RAC has been completely formed. We may, call on other experts, as it were, in the future. So we may have somebody join us in a future meeting if we need to and whatnot. So be surprised by that. But everybody else has been sworn into this gang, and there's only one way out, and that's making it through all the RAC meetings. And the draft proposed rules, so staff, especially Amber and Sheena, did the lion's share of preparing something for us to work off of. Again, this is really essentially a new rule set based off a very small portion of text from the special use rules. So they're to be credited with having done that, and you have been in receipt of a copy of that, and that's what we'll be dissecting today. And the RAC meetings, we're starting, of course, the first one today. Generally, the absolute minimum we would do for RAC meetings would be 2, 3 is about right, sometimes 4. So we'll shoot for 3 and see what happens. After that, we would have Department of Justice review the product of the meetings and then file the rules with the Secretary of State. Then we would issue a public notice of the Secretary of State filing, and that's the comment period where the public can chime in. And then our director and our land board would have to review and approve the rules before we do the final Secretary of State posting on the Oregon Administrative Rules database. So this is a much reduced version of what you were sent as far as rules or principles of how to act at the meeting. Essentially, it's how can we all be heard and get along well. And these are the highlights of that document. Review the background materials to discuss in the meetings before you get to the meetings. And we'll always try to have the products to you in plenty of time for that. Participate in all of the RAC meetings. Again, you can have somebody fill in for you if you can't attend. And to work collaboratively with the RAC and the Department of State Lands to achieve a consensus. And that you provide recommendations to the department regarding draft rules. With that, but as I go into rulemaking purpose and scope, I'm going to let Amber take the microphone helm again. Are you ready for this, Amber? Let me unmute her if I have her muted.
We don't have any controls, Chris.
Pardon me?
We don't have the ability to unmute ourselves.
I think you should be able to unmute yourself. I just wasn't sure if you were ready or not.
Okay. All right. So we have 20 minutes on the agenda to go over the rulemaking purpose and scope. I don't think it's going to take that long. But essentially, the reason we're here is the communication sites rules were originally in the special use rules, which was the department's Division 125 rules. Those rules related to communication leases were fairly vague, and they didn't have an established rate structure. The fees were kind of extremely vague. Oh, if I cut out, you guys, I'm getting a notification that my internet connection is not very good right now.
We're hearing you good so far, Amber.
Okay. So we didn't really have an established fee structure in the Division 125 rules, and we didn't have a great process set up for subleasing, or what we're going to refer to from now on as co-location. So what we would like to do as far as the purpose of Division 126 is create an entirely new set of rules just for communication sites facilities leasing. So that's the only thing that this set of rules will address. Through that, we will establish the leasing procedures. This includes application requirements, things that we might be looking for in applications would be the right business information, detailed drawings of the structures that a lessee would like to put in place, frequency information, what types of frequencies are used for different uses, like radio versus TV versus cellular, things like that. Other procedures that also require a process or an application process would be lease renewals. How are we going to address those and process those? Lease modifications is typically, as we proposed it, will be kind of a shortened application process where it doesn't need to go through a full public review, but it might just go to all of the lessees at the site to make sure that anything new being added is not going to interfere with anything that's existing. And then also, how do we hopefully come up with a streamlined process for lease assignments when a business sells to a new entity or just needs to transfer their lease into a different name. And then we don't come up with this scenario very often, but it's something that has to be addressed. So how do we deal with termination or default of lease? One of our biggest goals in this rulemaking effort is defining user categories. The way we have it proposed right now is in non-commercial, commercial, and cellular categories. The non-commercial and the commercial categories have subcategories the way that we've proposed it now. But those are definitely things that we hope to discuss in this meeting. Does that make sense? Does the number of categories we have make sense? Those type of things. Through this process, we want to make sure that we're incorporating industry best practices and standards. It would be helpful for us to understand a little bit about the different frequencies that are used for different uses. We want to make sure that we have modern terminology incorporated. It tends to happen that agency rules become outdated and we deal with outdated terminology, and then it doesn't make sense anymore. And in that regard, we want to make sure that we account for adaptive management through time so that the structures and procedures we set up now will make sense in the future and continue to benefit the management of state lands. One of the most difficult aspects we've had with communication site leases in particular is co-location or the sharing of lease space. We want to make sure that we have a structure that is kind of simple to address co-location. We've had it, the way the structure was in the past was based on a lessee sub-lessee relationship, but there was often so many parties involved that we'd have 6 subleases in place for 3 structures. So it didn't make sense to require people to have subleases back and forth between each other. So we want to streamline that process, kind of make it a one agreement type of deal where we have a base lessee and then there's a co-locator, but they also have a lease. And that way the base lessee doesn't have to deal with 6 different subleases if they have 6 different users on their towers. So each person or entity would be responsible for their equipment, and they would be paying for it through a co-location lease. That's what we've proposed at this point in time. So compensation and fees, we're not going to get to that today. We know that that's definitely going to be a hot topic, probably the most controversial of anything else that we have in these rules. But we do want to make sure that the fees that we've proposed or that we land on are appropriate to the use. We want to make sure that the application fees are fees that different users are able to pay that also cover the department's administrative costs. We want to make sure they're appropriate to the lease type, and there will be separate fees assigned for co-location agreements, application fees for a lease modification or a lease assignment. And then, of course, talk about the actual rent, which we refer to as compensation or lease compensation. And then on the same note, the rent that a co-locator would pay or co-location compensation. And scroll down for me, Chris. Thank you. So in meeting 1, we want to go over the leasing procedures, and we will go through the rules kind of section by section. But we want to make sure that we've got our application requirements dialed in, lease renewals, modifications, assignments, termination and default. Most of those have their own sections. So as we come upon the sections, we'll be talking about those subjects. Like I described, we want to talk about the different user categories that we've proposed, the non-commercial, commercial, and cellular, and then the potential to have subcategories for each of those categories. And then any information we can gain from you for our understanding related to the different uses and frequencies that go along with them. Modern terminology, let us know if there's something we've identified and we're not talking about it in the right way or the right terms. Please let us know. And then keeping in mind that we want these rules to last into the future. Rulemaking efforts are a huge process. They take lots and lots of time. They require public participation, such as yourselves who are here for this RAC meeting. So we want to make sure that we do the job right and that the work's going to last into the future. And with that, I think that brings us to a short break, if everybody's okay with that. There you go.
All right. So thank you, Amber. That was a great overview of the work that we're going to do today. And yes, as Amber said, we're calling a break now. And the idea is that if we were all here meeting in person, we might take a few more breaks and break it up, but we're going to try to really plow through things because we know it's hard to sit down at the computer for too long. So this is a good chance for you to refill your coffee or water bottle or use the restroom. We are going to give you 10 minutes because we committed to that. And then just be ready with sharp pencils and pens and eyes and ears and mouths to chime in. Once we get back from the break, which I'll tell you exactly what time to come back, Amber and Sheena will be leading the charge as far as presenting up on the screen what the draft rules look like and introducing each section as we talk through it. So with that, according to my watch, I have 2:38. So let's all be back in 10 minutes, please. Thank you. Okay, welcome back, everybody. Thank you for being timely in that. And I'm just going to be, we said we'd be totally transparent. So I'm going to confess that we thought when that break came up a little bit quicker than expected, we could have put it out, but it was roasting in this room. So we had to get a little fan going and some air circulation. So thank you for that. We're all set up for creature comfort now. So we're going to go ahead and dive in. Amber, as you can tell, is sharing. Oh, excuse me. Sheena is sharing a copy of the draft rules. And I just want to do a quick test here. So Gabe, I'm picking on you just because your picture is next to mine. Could you raise your hand real quick? I just want to, okay. Can you raise it electronically? There's a little button down at the bottom where it says reactions. You can raise your hand. Excellent. I just wanted to make sure that works. So we'll rely on that for people to raise their hands, or if there's not a lot of traffic, you can call out, say, you know, excuse me. But if I see your hand go up and somebody's in the middle of reading a paragraph, for instance, I'll keep an eye out, and I've probably seen you, but I'm going to wait till there's a break and then I'll say, oh yeah, Gabe has a question. So thank you for bearing with me on that test there, Gabe. With that, Amber, I'm handing the helm over to you.
Okay, well, I don't think our intent here is to read all of this line by line necessarily, but we do want to make sure that we capture any comments on any specific line necessary. So with the purpose and applicability of these rules, so this is for the granting and renewal of leases for communication site facilities on state-owned land. We didn't necessarily talk about DSL's land ownership as far as trust land versus statutory land. So if there's anybody that has questions about that, please feel free to let us know. But this set of rules is intended to work for any type of DSL owned land. The majority of our communication sites are on state trust land. So the revenues from state trust land contribute to the Common School Fund, and that is per the state constitution, that is our fiduciary obligation with trust lands. So the first section is pretty basic. Just says that we establish a process for authorizing these leases and granting the leases. And basically that these don't cover any other types of proprietary authorizations. So you can't get an easement through the communication sites rules, essentially. Does anybody have any questions on this section? Or comment?
You cut out. I didn't hear what you last said. Sorry for note taking. This is John.
Sure. So basically these rules don't apply to the granting of any other proprietary authorization through the department. An example of another authorization type would be an easement. So essentially you can't get an easement through the communication site rules. And that's basically it for the purpose and applicability. So if there's any questions or comments, please feel free to let us know. Okay, I don't see any hand raised. Is there somebody trying to speak?
Sorry about that. Sheena and I had a battle of microphones. I just wanted to say that the way John presented his question worked fine. There wasn't a competition of traffic. Feel free to try that as well, because I am struggling to be able to look at the full gallery of participants and see the screen at the same time. So if you raise your hand and it doesn't seem like I've heard you, feel free to pull a John, as it were. So thank you.
Okay, if we don't have any input on purpose or applicability, we'll move on to policies. So number one in policies talks about the Constitution, the state of Oregon Constitution, and our obligations to manage state trust lands. I would just like to point out that most of the stuff in this section is pretty boilerplate. We find it in the majority of all of our administrative rules for the department. So if there's something I see that is just specific to this rule, I'll be sure to let you know. But most of this has been taken from other sets of rules that we already have in place. So we manage our land to maximize long-term financial benefit for the Common School Fund. That's what number 2 says. Number 3, we do have an asset management plan that talks about generating revenue on all of our different land types. We also receive, we put all of our applications out for comments to federal, state, and local governments. All of our applications require signatures from county planning departments. The state has to make sure that anything that we authorize is in accordance to all local zoning ordinances or planning documents, and then of course follows all the other state and federal laws. So number 3 just says that we'll address all of those things.
Hey, Amber.
John?
Yes, I'm difficulty finding, and maybe it's in here somewhere. I haven't read the whole thing because I knew we weren't going to get all the way through it. So apologies if I should have done that in advance, and it's somewhere down at the bottom. But I'm having trouble figuring out what the rules apply to. Do they only apply to leases that are applications that are from the date the rules are enacted forward? Are they going to apply to renewal as well? Modifications, are they going to apply there? How are you going to existing contractual relationships? And I saw that you won't reach a lease.
Sure.
So you can tell me how it fits together?
Yeah, that's a good question. So as far as like the fee structure goes, or any of the application requirements that we decide on in this rulemaking process, those will be effective from the date that the rules are filed with the Secretary of State. That's when they become final, is when they're filed with the Secretary of State's office. So at that point in time, the rules will apply to every lease application moving forward. So those could be applications for renewals, modifications, assignments, or new leases from that date moving forward. As far as a lease renewal in relationship to a lease that's already in place, it depends on the language that is within that lease. So if one entity has a lease that allows for a 10-year renewal, then we will honor that 10-year renewal because it's in that lease contract. So that won't change, but the fees could change potentially depending on how the language in the lease is written. Does that answer your question?
Yes, that is helpful, and I'm looking at an actual lease because I happen to have one, right? And what that strikes me is that for every application, you're going to have to do an individualized analysis. Is that the intent?
Yes.
Okay.
Yep.
Thank you.
Yeah, and that's already the process anyways. Most of the analysis is done through the public review period. So we receive an application, the county planning department signs off on it. And that says whether or not the use is regulated currently within the zoning ordinances or whether or not it needs like a conditional use permit through the county. And then beyond that, it gets sent through the public review to other agencies, state agencies and federal agencies that have interest in things like endangered species, be it plants or animals. Our archaeologist reviews it. So it's not necessarily that the Department of State Lands completes the full review of all of those things, but through the public review process, all the agencies that are responsible for those types of laws get to review the application. Does that make a little more sense? Okay, so if we move on to number 4, this basically just says that, I'm echoing, communication sites are an allowable use on the Department of State lands property, and that we honor the provisions of the Telecommunications Act of 1996. I'm just going to move things around on my screen here. Number 5, each individual use or development placed on state-owned land will constitute a separate discrete activity subject to authorization and payment as required by these or other applicable department rules. And that is something that is common and standard across all of our administrative rules. Uses of we've already covered this in some way, but uses placed on state land.
Seeing what?
There you go. Will conform with local, state, and federal laws. The department will not grant communication.
Amber?
Sure.
Sorry, my microphone was muted. I was talking to a muted microphone. We're having an issue with displaying the text here. So if you can hold on for just a minute.
Can anybody see that text? Is it a white screen?
White screen.
Thank you.
Okay, give us a moment to correct that. Sorry to derail you midstream there, Amber. But you're seeing it on your. Do you want me to pull up a copy, see what happens?
I'm just gonna pull up a Word document and find it.
Okay.
Someone's working on the technical issues. Someone could explain what each individual use or development means for me in point 5.
Yeah, so that there's a little bit of interpretation in there because a development could be a tower plus the pad plus the building and the fence surrounding it. We would consider that all one development. But when it comes to easements, especially, and this doesn't address easements, but this is an example where an overhead electric line would be a different use than an internet cable that runs underground. So we would consider those discrete and different uses. So basically on a communication site, if you had something that was not related to your communication site's use, like you had a storage shed that had a lawnmower in it, that would be a different use that would require different authorization.
If it's all related to communication, would that be one development, one authorization? For example, if you had a microwave relay and a translator?
Correct, yes.
Okay. Thank you. Sorry to be that guy.
No, ask all the questions. Okay, I'm seeing the rules. Is everybody else?
Okay, so yeah, so as Amber just pointed out, the rules should be back on your screen, and during that little intermission, Sheena worked some magic and got the rules back up on the screen, but Steve had a great suggestion about following along with the version we sent. So well, I don't want to derail things now. I'll just ask in the behind the scenes if you can each try to have your copy ready in case we run into that issue again. That'd be very helpful so we don't lose any time. Thank you. Back to you, Amber.
All right, so we're in the policies section, number 7. Basically, what this says is we're not going to authorize anything that unreasonably impacts current uses, current frequencies or developments, or frequencies or developments that are proposed that were pre-existing to the application, or anything that's already in use at a particular communication site. We will use all the information we can to make that decision. So all of our applications go through the public review process. And within that review process, every leaseholder at the communication site is always notified. So this is where we want to make sure that if a new use or frequency is coming in, that the current leaseholders comment on it. And if a new use proposed is unreasonably impactful to the current uses, we would not authorize that potentially. So number 8 is a boilerplate thing that says uses must be authorized by a lease, and you cannot claim state land by adverse possession. Number 9 says that the department may conduct field inspections to make sure that the uses on state land are authorized and that they conform with the lease that authorized them. And if they don't, we will be able to pursue remedies available under law that ensure unauthorized uses are brought into compliance or removed from the property. So number 10, this might answer some of your questions, John. The department will honor terms and conditions of any existing valid lease or communication site facility granted by the department, including anything that entitles the lessee to renewal if the holder of the authorization has complied with all terms and conditions. And also if the holder applies for the renewal as described in these rules. So basically we will honor existing leases and valid renewals as long as they go through the process. So number 11, the department can deny communication site facilities authorizations if applicants' financial status or past business practices indicate that they may not fully meet the terms and conditions of communication site facilities authorization, or if what they're applying for is not intended to meet the provisions of these rules for a communication site facilities lease. So number 12, and I haven't asked if anybody has questions. I'm just assuming that if you do, you'll speak up, but now might be a good time to check in. Are there any questions so far?
Yeah, Amber, just so you know, I'm not seeing any hands, and there's been a little bit of some comments in the chat, but nothing that's a question that you haven't already addressed.
Okay, so the last.
Can I ask a question? Because apparently I need to talk a lot today. Apologies. But I'm assuming we're just looking at concept. We're not necessarily looking for readability or anything beyond that. Is that accurate?
Anything and everything. So if if there's something that doesn't make sense, please make sure and let us know as far as grammar or punctuation. But concept would be the biggest thing we're looking for.
Anything that you see, John, even if it's structural, like we tried to keep references intact where we move data or information around and that type of thing. So if you see anything like that, or even something as simple as punctuation, feel free to bring it up. Unless we get really compressed in conversation, then we can always make that the final chapter where we all go through it for readability.
Does anybody have any proposed language changes in what we've gone through so far?
And John, we see your comment and we'll file that and look at that. So he did have a editing comment on that section we just read. And again, we will be saving the chat itself, the transcription of the chat, but we're making notes when comments like this come up.
Yeah, so if you do have editing suggestions, please let us know. So number 12, this is the last one in policies. So the department may initiate projects involving communication sites, facilities, developments by ourselves or in conjunction with other entities. So this is saying, you know, if the department wanted to, we could put up our own tower and advertise it available for lease. And then we can also advertise properties for lease and request proposals for communication sites, facilities development on lands that we manage. And we have the ability to award leases through a competitive bid process. And then we also, number C, letter C says we can negotiate and accept compensation in the forms of services in lieu of monetary payments provided for in these rules. That is not something that's very common, but it has been done before. And those types of uses, I would say, would be things that were lower in value, like scientific research, because it would be hard to make up the monetary payments for a higher value lease. Sheena, do you want to go through the next section?
We're in meeting.
Okay, just wanted to make sure we're getting feedback when Chris and I both were trying to unmute at the same time. So I'm happy to go through that. Just to wrap it up, John, I see that you put another chat in, but I didn't get to read it. So 12C is actually a standard boilerplate language that is in all of our rules that allows us to accept a trade, basically, depending on what it is. Honestly, it rarely happens. So does that kind of answer your comment there? John?
I think his comment was something earlier.
Okay. All right, thank you, John. All right, looking at the definitions. Many of you probably know these terms because we've used them in conversation before. An applicant, any person applying for an authorization for a communication site. Appraised value is pretty standard as well. Estimate of the current fair market value property derived by a licensed independent appraiser. Typically, that's something that we would either, we would have to agree to that. We would have to pick an appraiser, the lessee or the applicant and us would have to pick an appraiser and agree upon that third party. Asset management plan, that is the grand plan for state lands, and it drives everything the agency does, the short and long-term management. The authorized area, this would be the area that's in the lease that's defined as like your lease area. That's your spot that you're paying for. The base lease is what comes into play when we're talking about between bases and a co-location. So the base lease, say, would be kind of explained as the base lessee owns the building and the towers, and then it has a co-location lease on it where somebody just has equipment in the building and on the tower, but doesn't actually have the structure. So a lot of these definitions kind of are intermingled and are basically just kind of meant to help with the rest of the rules at this point. We define, and this is one of the definitions where we'd like help on to make sure we got it right. We defined that cellular communications means the transmission and receiving of signals from mobile telecommunications over a cellular network operated by business entities that sell wireless cellular communication services. So if any of you cellular representatives here today, does that accurately summarize?
Or if there's a better,
Yeah, it actually encompasses the meaning of it. There's a one-off out there that Amber and she are aware of, which is FirstNet, which AT&T has the right to build out the FirstNet network throughout their network throughout all 50 states. And so that's a non, that's a not for profit, but it's linked to AT&T's network.
Right. We did think of that, Chip, in these when we were defining this. So a FirstNet site is not exclusively FirstNet, right? It's part of the cellular communications. So that would be a site that's still providing just regular old cell service. Is that correct?
Well, and it's new for me diving into the FirstNet since this AT&T project came on. And really what it is that AT&T has carved out their own spectrum or own frequency for FirstNet that is separate from everybody else. So it keeps the first responder 911 network separate from everybody else. So it is unto itself with its own frequencies. So, technically it's not part of that, but it is part of AT&T's offered services. It's a branch off of that, if that makes any sense.
Chip, I have a question for you. So in that case, AT&T is going to be the lessee and not the emergency services like state police?
Correct. Yep.
Okay. But also at those lease sites where AT&T puts up a tower for the purposes of FirstNet, would AT&T also be selling their cellular services outside of FirstNet?
Yeah, they're completely different frequencies and services. Like I said, it's a standalone for FirstNet on their own bandwidth. And so, yes, there are sites that I still work with that are not FirstNet involved with. It's, for example, the site we've been working on off Highway 78 south of Burns. That's a real particular prime example of the need of FirstNet to get access to that area of south of Burns that they currently don't have. And of course, it is a weak spot too for AT&T. So it's kind of a nice marriage between the two of them to get into that area. But like I said, I do work a lot of other locations that do not have FirstNet. It just depends on the connectivity needs for FirstNet and where they're weak or don't have, a signal within certain geographic areas.
So follow-up question, and we might need to get into this a little bit more when we get into the user categories. Is FirstNet, that contract that AT&T has, is that in any way like a sublessee or a co-locator, or is it just it's AT&T's business? Yeah,
it's an agreement that AT&T has with FirstNet, which is it's based on the AT&T winning the bid to build them out throughout the country. So I know I'm not quite explaining, but I can next time when we get into that particular area of discussion, I can bring more to the table in terms of the FirstNet and how it exactly works throughout the AT&T network and how it impacts situations like DSL land and co-location onto an existing or perhaps new site build for the carriers, whether and in this case it would just be AT&T because they're the only ones that have the right to get FirstNet out there and up and running.
Okay,
so Chip, would it be fair to say that AT&T is the host of the FirstNet
Correct.
network?
Yes. Mm-hmm. Yeah, that's accurate. Mm-hmm.
Okay. That explains it.
Yep. Very good.
So that being said, this number 6, that basically does count for commercial, you know, wireless cellular communication services. That's a solid definition for us then, regardless of FirstNet.
Yeah, regardless of FirstNet would be just piggybacks in certain areas of the AT&T network on their own, you know, frequency. So in all cases, still an AT&T or whoever it be, you know, it's still going to be a cellular service that's commercial.
Yeah.
Thanks for bringing that up, Chip. That was something we were curious about before. And I'll just say that if there's like a industry jargon definition that describes FirstNet or a few keywords, feel free to share that, whether it's in the chat or if you do an email, we'll just make sure we add it to the notes so everybody can see it. But thank you for clarifying how that works.
Yeah, you bet. And I can get something put together on FirstNet for you.
Thank you. That would be very helpful.
You.
Okay, so moving right along to co-location number 7, we just basically define that as one entity sharing the same communication site facility. And if anybody has any heartburn about any of these, please speak up. We defined commercial as a use that results in or is associated with monetary consideration or gain, a business entity that strives to make a financial profit. This does not apply to entities that are not for profit, 501c3 or governments. This number 9 is really important, and we really want some feedback on this one. It's kind of an older definition that we reworked a little bit. It's for the overall communication site facility. And we are defining that as it consists of towers, antennas, dishes, buildings, generators, propane tanks, solar panels, fences, and other associated structures or equipment used to transmit or receive radio, microwave, wireless communications, and other electronic signals. The roads, pipes, conduits, fiber optic, electrical, and other cables that cross state-owned land to serve a communications facility, however, are governed by the different administrative rules for granting easements over state-owned land. So we wanted to make that clear in this definition that the lines that connect to a site are governed by something else, are governed by the easement rules, which is divisions 122 and 123. So does anybody have any input on this one specifically?
So John has something in the comments about not-for-profit 501c12. Would AGC be moved to commercial under this? Oh, excuse me, that was Stephanie Bowen with Harney Electric Cooperative. Would Harney Electric Cooperative be moved to commercial under this definition?
So Stephanie, that was definitely a type of organization we did not know about. So if you are a not-for-profit entity, you would be non-commercial under our user structure or use category structure as it's proposed right now.
So Sheena, should, as far as updating this definition, so she's looking at number 8.
Yep.
Maybe we just say not for profit and scratch the 501c3.
We'll make a note and look at that for sure. We'll have to dive into that and see that sorry, I forgot what the reference was. 501c12, we'll have to look at that and see what that.
To be honest, I've never heard of that before, Stephanie.
Yep.
Oh, and 24. Okay.
Stephanie, you just made homework for us, so we're going to dive into that. I'm not sure about the answer to John's question. So John is asking about federal status of as far as not-for-profit versus state. That may be something we may need to talk to DOJ about how we've recognized that in the past or not. Do you want to add anything to that verbally, John, about the difference between state and federal?
I was just mentioning it as an option in changing your definition, so it might include definitions that might include entities that Stephanie's bringing up instead of listing a bunch of 501c3 or C12 or C12, C24 status, because there's probably other organizations too that you would consider would go in your tier that it may not be captured by appropriate federal status.
Very helpful. We just added what you said. I say we virtually, Aaron is scribbling madly. We just added what you your clarification you added to that. So thank you for that, John. I think we're ready to go forward then.
Moving right along.
So anyway, so everybody doesn't feel like those are something left hanging. We'll dive into all of that, do some research and share the results with everybody in the group.
So number 10, compensation. This is essentially the rent for a lease. The amount of money paid for a communication site facility leased to the department to use the department managed land. Decommissioning plan. This is a new one. In this, we decided it means a plan to retire and remove the physical facilities and or structures of a communication site facility, including but not limited to decontamination, dismantlement, site rehabilitation, costs and timelines for decommissioning. This would only come into play in the event of termination for default or abandonment or something to that effect.
Or lease expiration.
I can't, Chip, what'd you say?
Sorry, just added to it, just or lease expiration.
Yeah, as long as there's not a renewal. Yeah.
Right.
And all of these things we get into
following
further.
a renewal. If the renewals, if it comes to the end of life, then they're related language, and I think I have.
Yeah. So all of these things are kind of talked about more in depth in the body. This is, like I just said, the definitions. So they're kind of used more in context later in the document. So the department obviously means the Department of State Lands. The development, number 13, any structure or series of related structures authorized by the department on an area of state-owned land managed by the department. The director is the director of the Department of State Lands. Emergency services, this is another kind of use definition, means the local 911, emergency medical services, wildfire radio communications facilities, wildfire detection cameras, and or law enforcement services. And this, we specifically put in here that this does not include commercial wireless cellular facilities, which would mean the FirstNet sites. But we can look into more of that as we do some homework on FirstNet and with whatever Chip provides the group on what those mean and how they work.
Does it include an emergency alert system?
Yes, it would include an emergency alert system like Shakeout. Is that what you're thinking? Or
well, like OPB is the entry level to, or the entry point for all federal EAS notices, and so they're not. I wouldn't read that definition and see that qualifies. So I wanted to raise the issue.
Okay, I think we could probably add that.
Can you repeat that? OPB is the entry point system for all federal
emergency alert system.
Emergency alert systems.
So is that, John, would that be on a different, does that piggyback off of OPB's structures and towers and whatnot?
Yes.
Is it its own kind of system that's housed on your guys' structure?
No, it's a separate system at our headquarters where the message would come in from whoever sends the message, FEMA or whoever, and it goes out our broadcast system, and both radio and television, and they run tests to make sure that it goes all the way through the system to the end user, and so it's generally known as the EAS.
Stephanie has
Okay.
a question when we're done with this question. We're definitely getting some things to think about. Thank you, everybody.
Okay, so Stephanie's question says, could utilities be identified as emergency services as we play a key role in wildfire radio communication? We are usually required to be on the scene and use our communications equipment in these circumstances, just food for thought. So I think if you don't mind chiming in, Stephanie, because we do have the airtime, but when you say could utilities, I'm not sure whether to interpret that as a utility company or as infrastructure, but is this something that's separate than, it sounds like it is because you're describing communications equipment, but do you mind just touching on that a little bit?
Sure. Can you hear me?
Yep.
Yeah. So after dispatch gets a call for wildfire, we are typically called next because, power line and infrastructure is usually part of the strategy to be involved with that. And our linemen also, use our resources here to help with wildfire mitigation and response. So I'm just looking at the fee structure, kind of jumping ahead and just trying to make an argument that we could also probably fit into that category.
Okay, so I think that probably what part of the discussion will be is that is the infrastructure being used for something that's being used for profit or gain as well, or is it primarily or only for an emergency service that benefits the public? So that might be part of how we get into the weeds on that. But
yeah. Chris, I'd like to offer a suggestion. It might be that we need to identify primary and secondary lease uses because it seems to be a pattern that each of these users that would have a base lease have more than one use type. Typically. Does anybody else have input on that?
I see it sounds good. So I think that means we can, where would you want to talk about that at? I mean, we're kind of in definitions now, so maybe just to note it for now that we've all.
Well, yeah, I mean, it would end up being related to the fee structure. I think I would like to ask Gabe at ODOT, how many different types of uses do you manage within your lease?
I don't think we can do emergency services. I'd have to take a look.
Well, some of them are the state radio project, which is the original FirstNet with, I know some of the ones in Southwest Oregon have state police under ODOT's lease.
So no, well, we essentially absorbed Oregon State Police, so we kind of represent them when it comes to our wireless network. So we don't exactly have like leases with them.
Right. So but the uses that you might have on your tower at any one site could be state police, and then what other type of uses?
Yeah, we would have, what are the types of uses? So again, I don't think we would have about emergency services. So, and we do, and we host, we have other co-ops, we have other state agencies. We also have the Shakeout PNSN on our towers.
Okay. Yeah, and this is something we might need to think through a little bit more, but I just wanted some more examples if we could.
Okay, and just to kind of let the group know, what we will do is we will take this document and we will do our research and input suggested language changes in track change when we send it back out to you guys, so you can see where we made changes based on discussion and research coming from that and suggestions. So just please be aware that we will highlight where those changes are. Moving on to entity. That is just, entity is what we're going to call the individuals, corporations, association, firms, partnerships, LLCs, joint stock companies, nonprofit, basically anybody who's the applicant or who we're dealing with. In this document, they are referred to as the entity. Facility manager, this is an entity employed by a leaseholder to manage a communication site facility on their behalf for the purposes of site maintenance, management, and or administration. Holder is the entity which holds a communication site authorization. The lease is the contract. It's the written authorization issued by the department. The lessee is basically the entity holding the lease. Local commercial, this is another use category. And we define this as a for-profit entity that has business dealings and provides commercial products or services to a service area that does not extend beyond the boundaries of the state of Oregon. So basically, this would be a small business limited to the state of Oregon boundaries. Is there any heartburn or question about this?
Maybe we could go through regional commercial, just so they have context.
Yeah, so, well, down here we have national commercial, which would be a for-profit entity that has nationwide or international service areas where they, sell goods and services. And then we have down here regional commercial, which means by a for-profit entity that is limited to the state of Oregon and Washington, Idaho, Nevada, and California. So basically the states directly adjacent to Oregon would be regional commercial, and then beyond that would be the national/international commercial. So those would be the three use categories or subcategories for commercial uses. All right, I don't see any comments, so, or any hands raised on that one, on those. Market value is fairly obvious. It's the market value, probable price of as of a specified date in cash or in terms of equivalent to cash. International commercial, we just kind of talked about that. Non-commercial, we only listed the 501c3 here as well, but we can kind of take that out based on the previous comments about that and look more into what John was saying about that. So this definition will likely get reworked, but right now we kind of have it as a not-for-profit or nonprofit entity, local, state, county, state, federal, or tribal government, fire protection associations, quasi-government entities, and also includes the personal use and research and scientific use. Number 25 would be non-trust land. That is mostly small back lands and submerged and submersible lands. On the off chance that someone wants to put a pump site on an island in a river, it would kind of fall under this non-trust land category. Personal use, this is another use category. This is essentially for amateur radio communications with no monetary gain. So your hobbyist ham radio operator kind of deal. Regional commercial, we already kind of went over that. Research and scientific use. This is kind of like the seismic study, for research projects that are typically funded by grants. And they're kind of piggybacking on somebody else's site. It's usually a small thing. This is how they use these to transmit data. State-owned land is owned or managed by the department or its agents. That includes trust and non-trust land. Submerged land, this is part of the non-trust land thing. This is land lying below the line of ordinary low water of tidal, navigable, and tidally influenced water within the boundaries of the state of Oregon. Submersible land is land lying above the line of ordinary low water and below the line of ordinary high water for tidal, navigable, and tidally influenced water. Trust land, and that's where primarily all of our comm sites are currently located at. This is the land that was granted to the state upon its admission into the union or obtained by the state as the result of exchange of trust land or obtained in lieu of originally granted trust land, or we purchased it with trust funds or obtained through foreclosure of loans using trust funds. So that's the kind of the working definitions, and you might need to refer back to them as we're going through the document. So Amber, do you want to take this section? Application requirements.
This is a short one. It's pretty basic. I do want to point out that this is for lease, a new lease or a lease renewal. So any entity wanting to use state-owned land must submit a complete application on the form provided by the department and pay the non-refundable application processing fee. This does outline our application fees for non-commercial uses. Personal or research scientific is $250 is what we have proposed. Currently, I would just like to note that the current rules we have in place right now, all application fees are $750. So we did want to make all of the fees, including application fees, representative of the use. The research and scientific portion of it, those groups tend to have grant funded projects and they have a hard time paying those large application fees. So we wanted to make that representative. All other non-commercial uses would be a $500 application fee. Commercial use applications would be a $1,000 app fee. And then for cellular towers, $2,000 application fee. Unless otherwise allowed by the director, a fully completed application for lease must be submitted 180 calendar days prior to the proposed use or placement of a development subject to these rules. So we have some questions. So Stephanie's question is applications requirements for base leases or also co-location and subleases. Those application fees for co-locations and subleases are addressed in a different section. So this would just be a base lease or a lease renewal. The question before Stephanie's from John. Seems like the amount of work involved in a new application is significantly more than a renewal, but there's the same fee. That is a good comment. Let's see. Sheena, do you have any input on that?
I was actually just looking ahead in the renewal section. If I can find it someday. I think with what we're proposing to do with renewals, it would be fair to have a lower application fee for a renewal. In the past, renewals have always been treated as, or I guess processed as a new application on our end, which it does take more effort on our part. It is a bigger workload. What we are proposing to do with renewals going forward is hopefully going to be a much more streamlined process, which would support a lower application fee. So I think we can take that under consideration, absolutely.
And I've commented that in our draft of the rules. And then we have a third question from Steve Quick. Where did these numbers come from? Other states. So these numbers, yes, we did do a rate study, which we haven't provided everybody yet, that looked at other states and also looked at the federal government and the fees that they charge. So prior to the second RAC meeting, we will be giving you all of the information on where we got our numbers for lease fees in particular, but also all of the other fees that we've outlined. And when I say other states, another point to note about trust lands or common school fund trust lands is there's 23 Western states that have that same land base in common, basically everything west of the Mississippi. And so that grouping of states has an association that represents them. And so we can go to that association in any of those states and see how they manage their common school fund trust lands. So those are the states that we look to for those numbers. We wouldn't necessarily look to the East Coast because they wouldn't have the same land base in common. Any other questions at this point?
I see that somebody put a comment up, but I can't see who did it. Oh,
Which
Yes,
I think
so Stephanie Bowen has another question. Should there be a requirement in here for how quickly the department turns the application around after receiving? So that is where number 3 of the application requirements comes in. We are requesting the applicant to provide us an application 180 days prior. So that's kind of our time frame identified there is, 6 months in advance of when you intend on using the site. It doesn't mean necessarily that we have to process it within 180 days, but that would be our goal.
And we'd be open input on that and open to input on the language of 3, because it really doesn't, it implies, but really doesn't hold DSL to a timeline.
but should it be required to be processed?
Yeah.
Honestly, we try to get it processed in that timeline. A lot of the times it depends on the complexity of the site, but also the back and forth with making sure we have a complete application.
Oh boy, 6 years.
We really try to get it done before that. As long as we beat the feds, we're doing good. We really do try to get it turned around at least that fast. Sometimes it just depends on the complexity of the site, especially if it's a new site or a new application. It's going to take a while because there's site development involved. Some of the times it's really just the back and forth with, depending on what comments you get out of the public review period, that kind of thing.
Or what types of negotiation you're trying to do with the lease language, because sometimes legal departments don't agree on legal language. So there's a lot of time where we have to do back and forth with lawyers, and that usually isn't a quick process. So I've included your comment in this section. It's definitely something we consider, but maybe there could be a caveat where We must identify to the user that the lease has been accepted or rejected within 180 days. Because sometimes the negotiations just take longer than 6 months.
We'll definitely take a stab at putting some more committal language in there. It may not necessarily fall in there though, because I think our thinking under this is requirements of the applicant. So maybe there's somewhere else that it fits. It kind of fits in here because it's our response to the application. But for now, we have noted it and we'll take a stab at writing something. However, Stephanie, I wanted to ask you if you could clarify part of your comment. Let's see here. It was, oh no, it's John's comment. John, your last comment starts about that you're a regulation reader, not a drafter. Do you mind helping us get the gist of what you're shooting for there?
Yes, the regulation on the application requirements, unless you read the title with the rest of the body, you wouldn't necessarily know that it applies to both lease and lease renewals. And so I'm not sure how to properly draft regs. I've never sat on a committee like this, but when I've read them, most of the time from the body itself, I get the full picture.
Mm-hmm.
And really the title is for the table of contents and to get me where I need to go.
Okay, good point. We'll make a note of that too.
So I just kind of scrolled ahead. I don't know if you guys saw that on the screen share, into the application review and approval process. That would probably be the place where we would put that deadline as far as
when DSL will respond.
When we will respond. And under this, basically our process is that we will, when we receive an application, we evaluate it for completeness. And that includes all the supplemental documentation, the diagrams, the frequency forms, and that's the information that we PRP out and in the public review process to make sure that frequencies are gonna work okay, and that whatever other interested parties and stakeholders have a say in the application. But once it's complete, we basically will contact you. Once the application is complete, we would contact you and say, okay, this is going to PRP, which means it's moving in the process. So are you guys talking about a deadline from like application to issuance of a lease, or what? What are you talking about with deadlines exactly?
Yeah, I think they mean actually having the lease issued.
Yeah, it would be really nice to have some sort of something in there, but yeah, I don't know if we would be able to stick to it a lot of the time, depending on the complexity of the site.
Yeah, we'll take a stab at something, see if we can come up with.
We can take a stab, yeah.
And I added a comment on the review and approval process, Sheena, for us to consider it in this section.
Okay, thank you.
Anything before we move on?
I don't see any more hands up or chat comments popping up, Amber.
There's one from John.
Did you say something, John?
In the comments.
Oh.
I would just advise against.
Go ahead.
Oh, I got you.
Yes, John, we agree.
Yep. We'll see what we can come up with. Maybe there's some.
I think we could definitely put in a deadline that's for between application submittal and whether or not it's moving forward, i.e. going to PRP. And that's already kind of in here, but again, as some of the lessees in this group could probably say, getting all the supplemental information together can be fairly difficult sometimes, depending on who's in charge of what in your organization. So
it's also probably way more important for new applicants than it is for renewal applications.
Yes.
Most renewal applications, they're just sitting on the site and it'll work out in time. It's no big deal, right? It's just how big the check's going to accrue up until the new lease is signed. But for new applications, that could have catastrophic impacts if they have to sit and sit and sit. So,
And we're all, sorry, I was just going to say we're all about plagiarizing. So I see Stephanie offered a suggestion to look to the USDA Farm Service. So we'll look at what they have.
And I've
Hey, Chris,
recorded that.
go ahead. Chris, this is Chip.
Chip, fire away.
Within the state, is there any avenue for applications and leasing to be done concurrently? And on top of that, at least from the communication side, we also deal with the local jurisdiction through land use and the building department. And each one takes a lot of time, as we all know. But I'm just wondering if there's an avenue in the future where a lot of this stuff could be done concurrently.
Could be done. What was the last part of your comment, Chip?
Being done concurrent.
Oh, concurrently.
You know, or after a period of time, we know that, you know, you have a complete application that's accurate. And then from there, that kind of starts other wheels going at the same time. And of course, I guess a lot of that is predicated by whether or not there's going to be, you know, it would be on the ODSL paper, the lease. But if there's a possibility in the future, what the carriers do is and it would be some form similar to this, is just a thought, would be a master lease agreement. So you have set language that really, because we all know lease negotiations can be forever, but when you encounter that with a master lease agreement, pretty much everything's been hashed out already between legal counsels, which actually can help the process through being concurrent through land use, leasing, you know, real estate, and actually the application with ODSL. Just a thought, just wondering if that's even a possibility.
Well, and a good thought. We'll make a note of that and look into that as well.
Chip, we might
Thank
have
you.
some follow-up questions on that. Are you talking about like getting, you know, site approvals through the county or conditional use approvals through the county concurrently with getting a lease with DSL, that type of thing?
Well, no, it's more based on the process for each of those three areas being, you know, the planning department, the leasing, and then also the application to DSL. They're all concurrent to a degree. I mean, there's got to be a gate somewhere, you know, like it could be, it's confirmed that the application is complete and there's no more additional add-ins or requirements from DSL to put into that because it is deemed complete. And then from there, that just triggers the next stages. And so I'm wondering if, because the goal with anybody would be, what's our timeline here? We've, like it's been mentioned, some projects take, you know, 1 year or 6 years. And I'm just trying to think of what can we do to streamline the process for everybody so it's less effort on anybody's part and everything's going along smoothly concurrently. And I'm
So
not sure.
Chip,
Mm-hmm.
I kind of know where you're coming from on that based on the site we're working on. Part of our problem is we run into a catch-22 with, we are obligated to ensure that we're not issuing a lease or moving an application through the process that is in violation or has not been signed off on by county planning and any other local, state, or federal law. So we can't knowingly, and a lot of times, like move forward without that county planning signature, because we have to make sure that the local county ordinances are on board with the potential project. Because if they're not on board, that just stops it right then and there anyways. And that's where we run into the catch-22, especially in site development. Like, I know the issues you're facing trying to navigate the county processes while trying to navigate our processes. And that's really something we would tackle on a case-by-case basis. So yes, we do like streamlined processes though. It would be nice.
So I would like to propose, because it's 4 o'clock and I feel like we're making good momentum though. So I'd like to keep up the momentum if we could. but I don't want to burn any bridges with our stakeholders too. So what I was going to ask in just a moment is if maybe I'll ask, Sheena, are you still sharing or is this Amber sharing? Okay, I couldn't remember when you ran into the blank page scenario. So I might ask Sheena to stop sharing for just a moment so I could see everybody on the screen at once, and I might take a quick poll to see if everybody's okay with forging ahead for another 30 minutes or another hour, just kind of see where we're at. Before I do that though, I just want to check in with Erin, because if she's scribbling away half as madly as we are in this room, she's got a lot of notes. So I just want to make sure she's still hearing us okay and able to track the conversation.
Yep, I'm good.
Thank you, Erin. So with that, let's go ahead and if everybody's willing to forge ahead for at least say another 30 minutes, if you could go ahead and raise your hand and I'll just look for a number of hands that go up.
My hand's up, Chris. This is Chip.
Okay.
All right, looks like we're good to go.
Okay, lots of hands up. Let's forge ahead for at least 30 minutes, then we'll do another poll at that time. And if we've are at a good breaking point and people's minds are reeling or whatever, we can decide to break then. But thank you very much. So we'll go on ahead. Oh, but with that, let's take a quick 3 minute. If you're like me, you drink a lot of water when you're talking. So 3 minutes, if we can be back at 4. If you got to refill your water or your coffee or do a quick bio break, please do that. Thank you. Where's my? All right, thank you, everybody. Hopefully you're all good to go now. Amber, do you want to lead us further ahead?
Sure. So we'll jump into the lease application review and approval process. So the department receives an application And then we will determine if it's complete and accurate, including all the required documentation. If the subject area is available for the requested use. The type of use being requested through the application, and this would come back to our categories of non-commercial, commercial, or cellular communications. Sorry, I opened my window, but it's noisy out there. So these categories could be used to determine the amount of compensation payable to the department. So that is something we would look at during the application review process. So you wouldn't go into a lease without knowing what you were going to be charged. We would also determine if these rules are the appropriate rules for the authorization. If there's another authorization that might be required under a separate set of rules through the department, such as easements. If there's any additional information that we need, and that additional information could be concerning the proposed use of the state land or concerning the financial status or business or management practices of the applicant, or if the equipment and structures described in the application will be the property of the applicant or another entity. We'll come back to that later, but we run into a lot of subcontractors submitting applications, and we really want to be dealing with the lessee through the whole process. It just makes things a lot simpler on our end, and the signatures that we require to process an application have to be those of the lessee, which would be the same entity that owns the equipment or the structures that would be installed on state land. Most of the areas where we've run into the subcontractor issue is with cellular sites, but we want to make sure that the applicant that we're talking to is actually the owner of the structures that are going to be installed. So once we've reviewed the application for completeness, we will notify the applicant of our determination concerning each of the factors we just talked about. If it's incomplete or incompatible, then we would return the application to the applicant with a written explanation of the reasons for rejection. I heard a noise, but I don't know what it's for.
I think Chip got bumped out. We just let him back in. He should be on in a second.
Okay.
Can you hear us okay now, Chip? Chip, can you hear us?
You have to unmute him.
I'm back. I'm having connection problems.
No problem. We saw you trying to get back on. Can you hear us okay now?
I do now. Yeah, thank you.
Okay, thank you, Chip. Sorry, Amber.
But can we go to 1A, B, C through F there for a second?
Sure.
I think, I'm not sure I'm reading this correctly, but there are three conditions of F, right? If the additional information is required concerning the A, B, and C.
Mm-hmm.
I think you have an and after the A clause, and it should be after the B clause, and there should be a semicolon there instead of a period.
Yep.
Right?
Good catch.
Good catch. Thank you.
Okay, we have that noted. Thank you. So going back to number 2, so the department will advise the applicant of the determination whether the application is complete. And if it's not, we will return the application to the applicant with written explanation of the reasons for rejection. Number 3, if an application is rejected for incompleteness, it must be resubmitted within 90 calendar days from the date that we returned it. and no additional application fee will be required in that instance if you get it back to us in 90 days. Number 4, if we receive more than one application for a specific area, for a same use or a similar use that could be conflicting, we might take a look at the multiple applications and determine which proposed application best fulfills the policies in these rules, and accept and proceed with that application and deny the others. Or if neither use is determined to be better, make the subject area available by to the public by auction. So that would be the competitive bid process. Is there any questions so far? Okay.
I'm not familiar with that with that system, but how does the aggrieved party get recourse there? What typically happens in this situation, and has it ever happened?
It happens for communication sites. I don't think it's ever happened. The competitive bid process and making things available to the public by auction in the event of multiple applications at the same time is something that very rarely happens. And the competitive bid thing, we basically have to have that in there because we are a trust agency. We are managing trust lands. So
sure, I'm more referring to clause A. Does the Department of State Lands ever find one purpose is demonstrably better than another and tell someone else no thanks?
That hasn't.
We've done it in other programs. I don't think it's ever happened in the communication sites program.
Okay, then never mind. I'm good with the language. If it never happens, I'm good with the language as is. There's nothing to worry.
Yeah, I don't think and maybe Sean or Amber can chime in on that. I just don't think it's ever happened in this program. So.
Not
This
that
is-
I'm aware of. Go ahead, Sean.
This is Sean. This is, it's never happened in the time I've been with DSL.
Thank you, Sean.
Yep.
Yeah, and I think that if that were to occur, the department would consider the obligations to the common school fund, the impacts to the land, and all of those types of things would go into that consideration. So it wouldn't be based on, the department likes this use or this user better. It would be fully analyzed by the benefit to the common school fund as well as the impacts to the property. And I mean, if you're suggesting not to keep it, then we could consider that as well. And then I will add your comment about how would they have recourse. Okay, so moving on. So once we accept an application for a new lease, then this is where we talk about our public review process. So it will be circulated to various local, state, and federal agencies and other interested persons, including tribal governments, adjacent property holders, affected lessees and permittees, and easement holders for review and comment. As part of this review, the department will specifically request comments concerning the presence of state or federal listed threatened and endangered species, including candidate species, and archaeological and historic resources within the requested area that may be disturbed by the proposed use, and conformance of the proposed use with local, state, and federal laws and rules, and conformance of the proposed use with local comprehensive land use planning and zoning ordinances, conformance with the policies described in these rules, and any potential conflicts of the proposed use with existing or proposed uses of the requested area. So that is our public review process. I do want to let people know when we say interested persons, there are through the department, there are listservs that people can sign up for. So if like a environmental group or something said they wanted to receive notifications of all of our leases, it would go to those groups as well as the parties that we've named specifically.
I think you've got some extra ands on A, B, and C there you can scratch.
Okay. Let's see. Lori, do you want to tell us a little more about what you mean NEPA review through tribal governments? Lori, if you're trying to talk, you're muted at this point.
Lori, if you're talking, we can't hear you.
Okay, so Chris, can you try and unmute Lori?
You bet. Give me just a second here.
So 6A, tribal governments do NEPA review to make sure all lands have no tribal artifacts. So
She's typing her comment.
Oh, okay.
You can talk also, so thank you.
Yeah, so we do typically have contacts with each of the tribes that
Yeah, I
get
see tribal review, so, but that should also probably be included in the B. Conformance of proposed use by this local, state, federal laws and rules. C, under the review and NEPA. I mean, they've got to be approved by NEPA also. And that may be included in the other rules, but I haven't seen that yet.
So we typically require an archaeological survey, well, a review by
Okay,
our
down below.
Sorry, what?
8HCB says archaeological and historic resources within the requested area.
Yeah.
Okay.
Yeah. And if there's ground disturbing activities, we do require a survey. It has to have the SHPO concurrence, all of
Good.
that.
Perfect.
Okay.
Thank
All right.
you.
Oh, thank you.
This
Thank
is
you, Lori.
Cassie. I'm just going to pop up and just recommend that there should also be communication and coordination with the tribes. That, speaking as a tribal representative, that doesn't happen. And SHPO is not the know-all, end-all, be-all of archaeological and cultural resources, and resources are often damaged by projects like this because nobody's talking to the tribes. So
Thank you. Yes.
So I heard your point there, Cassie. I'm just wondering if you're recommending beefing up a particular clause that we're looking at here.
Possibly. I'm trying to find the full document. I had it here a second ago. And
Oh, no problem.
it's a little hard to read it on this.
Yeah, and I will say too, Cassie, that we do have specific contacts with each tribe, and they typically are the TIPOs for the tribe, the tribal historic preservation officers. So
yeah, so again, I am the TIPO for Cokewell, and I don't get these communications.
okay, well, we will definitely make sure that our records are updated, and through this process, we can make outreach to all the tribes to update those contacts. And I guess I would offer too that one reason you may not get notifications is there may not be any of these activities in the area near your tribe. Most of our communication sites right now are in Eastern Oregon in Harney County. So that might be one reason that you haven't seen a notification for this particular use.
Sure, that's entirely possible. I've been here for 7 years, but I'm gonna work on trying to clean up or provide some suggested language.
Thank you.
Thank you, Cassie.
John?
Yes, is it the intent of this provision or the practice of DSL that every time there is a new lease, no matter how significant, whether they're breaking ground or adding an antenna on a tower, that you do contact tribal governments, adjacent property holders, affected lessees and permittees and easement holders? Because that's the way it reads. You may want, if it's not, then you want to maybe replace including with may include.
So I would say this definitely applies to all new lease requests or new lease applications. If lessee wants to replace equipment on a tower that doesn't change the use or the footprint, then we don't have to go through that process. That's covered in the lease. So
I'm not referring to the process. I'm referring to, if it's a new lease, do you always contact everybody following the word including, no matter how significant the lease or not? And if you always do, then the wording is fine. If you don't always do that, for example, if you have a site that doesn't have an adjacent property holder, or there isn't a tribal government that was relevant, or the lease would be for something that couldn't possibly disturb ground or impact some of those people after the word including, then you may want to change the word.
okay, I see what you're saying. I would say if they're relevant, then yes, we always do, but there may be a case where there might not be an adjacent property holder. So you propose changing a word to may include?
That's what, if you don't always have to do that, have to contact everybody after the word including, then you should replace it with may include.
Which line are you looking at specifically?
The second line in B5.
You,
And while I'm on a roll.
Yeah, that's okay. That's why you're here. I think we'll highlight that one and maybe take a new look at that, how we can tweak that.
While I'm on a roll, I don't know what acceptance means. Does that mean receipt of a completed application?
That means,
yeah. It means acceptance of a completed application.
Okay.
yeah, I'm still not seeing where that including is.
Are you talking the second line in number 5?
Yeah.
Let me scroll up. Where it says upon acceptance by the department, the application for a new lease will be circulated, or it says may be circulated.
Oh, I see. Okay.
It says will, which means it's non-discretionary. You will do it.
Yeah.
But then also you have your various, right? So I suspect you do that all the time.
Yes.
But
for a new application, yes.
Yeah, I suspect you do that all the time with local, state, and federal agencies and other interested persons. But then you have including, and everything of including means that they have to be notified and receive whatever your application circulation process is, and you may not have those there.
Sure.
And I don't know if you do or not. It's something that unless you want to be roped into it, you might want to consider it.
Well, there isn't any other affected, like if there isn't any affected lease easement holders, then we wouldn't send it to them. Like, we're not going to send out notifications to all of our easement holders across the state for one thing. It's just who is in the area, who is adjacent, and could potentially be affected.
Okay.
Yeah, we might be able to add a word or two that talks about whether it's pertinent or not, and instead of just turning will to may, but to kind of clarify that where it's applicable or appropriate somehow.
Yes, and that's Stephanie added comments to that nature, and I have captured
Okay.
all of those comments so far. So thank you, John, and thank you, Stephanie. Okay, anything else on number 5?
Yeah.
So just for clarification, this is Cassie Rippey. Again, the department will specifically request comments concerning and then the following. So they're requesting comments from whom?
From all the groups listed under number 5 and whoever else. Yeah.
Does that answer your question?
Yeah, I think so.
Okay, so number 6, the department will request comments from the Federal Communications Commission, Oregon Public Utility Commission, Federal Aviation Administration, U.S. Department of Defense, any other entities owning or leasing communication sites, facilities at the leased location, and any other interested parties who advise the department that they want to receive such applications. So this is in addition to number 5.
Again, do you do this for every lease? Do you do this for a ham radio operator? Maybe, I don't know. But you're saying that you will.
Right. That's a good point. That is
That's a good spot to put a may in.
Yeah, the department may. Okay. Noted. The department may post such a notice of an application and opportunity to comment at a local government building, public library, or other appropriate locations to ensure that minority and low-income communities are included and aware of the proposed use. The department shall make paper copies of an application available to any person upon request. And that is in all of our administrative rules. So we've requested comments, and after we receive comments concerning the proposed use, the department will advise the applicant in writing if the changes in the use or the requested lease area are necessary to respond to the comments received. So if changes in the use or the requested lease area are necessary. So basically, when an application goes out for public review and we get comments back about archaeological or historical resources, we tell the applicant, we've been advised that an archaeological survey needs to be completed. Applicant, you need to complete that before we can issue the lease. So if there's changes in the size of the area because of the impacts, if we receive those types of comments, we would pass that on to the applicant and ask them to address it. So we will also advise the applicant in writing if existing authorized frequencies are senior in right to a new request. Any interference identified as a result of the proposed use must be addressed by the applicant. And if additional information is required from the applicant, which might include surveys of state or federally listed threatened and endangered species, including candidate species within the requested area, or archaeological and historic resources within the requested area.
There's a comment from Stephanie.
Yes, thank you, Erin. So Stephanie Bowen asked, do these have timelines? How long is the notice posted? How long does the department have to inform the applicant? And how long does the applicant have to address the comments? Great questions. So our public review period for a new lease is 30 days. That's our standard public review period. So once we post it and we send it to all the interested parties that we've described, they have 30 days to give us comments back. Once we get those comments back, then we provide those to the applicant. So, you know, that could be day 31, or it could be within a couple weeks. We don't have set timelines for that at this point in time. It usually doesn't take us that long, but typically, you know, within a couple weeks or a month of the public review period, depending on the workload at the time, we will get back to the applicant. How long does the applicant have to address the comments? That is a good question. I don't think we actually have that addressed in rule. We already said if the application was incomplete, you had to get it back to us in 90 days, but that's a different scenario. So at this point in time, I don't think we have a timeline on that. Sheena, do you have anything to add?
Yeah, this is typically, we leave this open-ended because dependent upon the comments we receive, it could take some amount of time for the applicant to work through those, for us and the applicant to work through those comments and make whatever changes are necessary, if there are any changes necessary. If something, like if we get something back from like one of the tribes or from SHPO or something that says, hey, there might be cultural resources on this site, then we would have to go through the survey. And if the survey reveals that there's something there that could potentially, you know, we would maybe need to move the site, move the structures or replan something, then we would definitely, it would take more time to hash that out. And so that's kind of why there's no deadlines on this. It's really case by case dependent and kind of difficult to put a deadline on. If it's an existing site that we're PRPing here, you know, obviously there's not going to be as many comments and therefore it's going to go faster. But if it's a new site, a new development, it'll go a lot slower. Does that make sense? Yes, Stephanie.
And there, and in the middle of that, Cassie had a comment about recognizing that the tribes are not members of the public.
Yes.
Yeah.
Yes.
Okay, I'm just going to take a second to note Stephanie's comments. Those are all very good questions.
While you're doing that, I'm going to scroll back and make sure we haven't missed some here because
Yeah, I think we might have missed Cassie's comment about requiring an archaeological survey. Is that outlined in the rules?
Yeah, I do feel like I'm not seeing all the comments that come up. And John, I see that your hand's up, but give us just a moment.
Oh, here we go. So Cassie's comment, you mentioned that you usually request or require an archaeological survey. Is that outlined in these rules somewhere?
I don't know that it is specifically. It is our practice as an agency that any ground disturbing activity or potentially ground disturbing activity requires an archaeological survey.
HCB.
I mean,
Yeah, that would be as required. DSL also has an archaeologist on staff. So if it was his recommendation about DSL's land, then we would recommend a survey. I know that a site like Burns View is already very heavily disturbed and it's been surveyed multiples of times. So in some cases, he doesn't require a survey. So it would come back to DSL's archaeological staff recommendation as well.
And also just 8 little c big B is essentially saying that we would let the applicant know if archaeological survey was required. Additionally.
Sure. Yeah, thanks. The way that I read this, you know, one of my concerns is that, and just from my experience working with folks, they say, okay, well, you've told me that there aren't any known in the area, but you haven't told me I have to do it. Or you are telling me that there are, but you're not saying that I'm required to do X, Y, Z, because technically SHPO doesn't actually, they don't actually have the authority to require a survey unless they're, you know, if there's a known site, then, you know, work has to have a permit, but they can't require a survey. So that's why I'm asking how DSL addresses this, and if that's in some portion of their of your rules, or in some policy somewhere that talks about it, because it's really not clear anywhere.
I could just say that, this is Sean, that whenever we get, you know, recommendation, because that's what SHPO will do, or the tribes, they'll recommend that a survey be done. And when we get a recommendation from the tribe, we will require one.
Okay. That would be as the landowner, because DSL is the landowner. So we would have the right to require it at that point.
Just scrolling through the chats as we go along here.
Can you scroll back up to John's message that he just wrote on the chat?
Yep, real quick, just to let everybody know, Steve had to bow out, so we'll catch up with him in RAC number 2. This one?
Yes. It would be. We would actually tell the applicant, John, immediately that with a new application for a new development that would be breaking ground, we would tell them immediately it's going to require an archaeological survey. So that wouldn't be any kind of new information after an application. It would be, you know, one of the first things we throw out.
Is there a reason not to codify that?
Nope. In fact, I was just thinking of where we could put something like that.
I think we'd go up to application somewhere, but maybe target that as something that we might see a proposed language in the next round.
I'm going to do another quick poll because we just lost Steve, and I want to make sure, because we asked everybody to hold tight till 4:30 and we hit 4:30. So I want to see how folks are doing, because we do not have any qualms about adding meetings to the series if we need to do that to make sure we're getting good representation. So let me ask Sheena if you'll stop sharing for a second, and I can get everybody up on the screen here real quick.
There you go.
And there's no pressure here. So John, your hand is up. Is that for a comment or for the poll I'm about to take? His hand is down. I heard it whoosh as it went down. So I'm going to do a quick poll. Again, there's no pressure for anybody to say that they will stick around or not. So if you have something really pressing or you just can't handle anymore today, let's raise our hands or not appropriately. And I'd just like to take a poll and see who would be in this for another 30 minutes. So keep your hand down if you are ready to throw in the towel for the day, and we will put pause exactly where we're at and make sure everybody gets the notes of where we've left off and comments, and fish for more detailed information on people that have made suggestions. So with that, if you're in it for till 5 o'clock, raise your hand. Pardon me? Oh, I think we got most everybody. Lori's raising her hand the traditional way. So
yeah, I'm good.
Yeah, we see you, Lori. Thank you for doing that.
Okay. Yeah.
John, are you needing to bow out?
I put it in the chat that I would just follow the group.
Oh, okay. I have so I'm struggling to keep up with the chatter here. So it looks like we have Yeah, we have enough of a consensus to forge ahead and we could at least get through this section. We're getting some really good comments that are going to give us some really good homework, and that way we don't leave with half of an assignment hanging. So let's forge ahead. I'm sorry if I interrupted you, Amber, and Sheena, feel free to re-share your screen when you're ready. So you can put your hands back down. That way, if you have a question, we'll know it's a fresh hand. So Stephanie, is your hand left up from the, oh, nope. John, is your hand a fresh hand up or, okay. Go ahead, we can hear you.
So on section 8, so if you could scan up a little bit. There you go. A, we need to remove the and.
Okay, yes, I already crossed them off my paper copy in front of me.
And then B, having a period in the middle of a colon, semicolon list is kind of weird. I'm wondering if we could rephrase that. And as it reads right now, it's not a complete sentence. We'll advise the applicant in writing existing authorized frequencies are senior and right to new requests. Yeah. Yes. Yes. Something like that.
You got that, Sheena?
Yep.
Okay. Thank you, John. And is your hand left up or do you have another point?
We have an extra period after, oh no, sorry. Yeah, I'm trying to scan on yours. Look,
That's okay.
I'm good. I'm good. If I have something else come up, I'll raise my hand
thank
again.
you.
I just want to know that Stephanie said she needs to be done at 5, so we'll go through the summary. We'll go through the summary prior to 5.
I feel like we'll be done before 5, so I appreciate everybody sticking around the extra 20, 25 minutes, whatever it ends up being. Thank you very much.
Okay, so we have been talking about archaeological resources. So little d is where we left off. So we will notify the applicant in writing if the area requested for the lease will be authorized for use by the applicant through a lease, and whether the subject area will be made available to the public through competitive bidding pursuant to these rules. So that shouldn't be an and, that should be an or. So whether or not we're going to award the lease to the applicant or put it out to competitive bidding. So 9, upon acceptance by the department of a lease renewal application, the department will determine if there is a change in use or size of the authorized area or frequencies. And if the department determines there is a change in use, authorization area, or frequency, the application will be processed as described in 141, 126, 140, 1 through 8. And I believe that's the section we're in. So numbers 1 through 8.
I think we just got through.
B, if the department determines there is no change in use, authorized area, or frequency, and the holder has fully complied with the terms of the lease, applicable statutes and administrative rules, and the holder of the lease has fully complied with any other authorization granted to them by the department, the holder may be eligible for lease renewal term as conditioned in the lease. So those A and B's just applied to lease renewals. So if there is a change in use, then we go through the whole big process that we just talked through. And if there's not a change in use, then let's move on to C. If the department determines the renewal complies with the requirements of number 9, the department shall provide written notice to the holder that the lease has been renewed for the additional term as stated in the notice. As a condition of renewal, the department shall have the right to require amendment to the terms and conditions of the lease at the time of renewal. If the lease contains a provision requiring that the annual compensation be redetermined upon renewal, the written notice from the department shall include the new annual compensation rate. So this is basically saying that if there's not a change in the use, there's not been a significant change in the lease area, and there's no changes in frequencies, so basically no change in use, then we will notify you essentially that the lease will be renewed without going through the big drawn out public review process. All right,
Thank you.
John.
Oh, you saw it. Okay, good eye.
So first, I think the flush language on 9 as a sentence by itself doesn't need the semicolon and the and that's more consistent with you having periods after A, B, and C, and all of them.
Okay.
Second, I want to talk about the C. As a condition of renewal, the department shall have the right to require amendment to the terms and conditions of the lease at the time of renewal. I'm not wild about that provision.
The condition of renewal.
It seems a little bit inconsistent with the provision above that will respect leases, which I characterize as good deal, bad deal, a deal's a deal, which I do like. I like that provision a lot.
Okay. So shall have the right to require amendment. So I think the reason this is in here is because DOJ tends to make changes to our lease templates. So that's kind of just to allow for new legal language. There could also be the case that, you know, maybe a statute has changed and now we require bonds for everything, no matter what. And maybe that wasn't a condition in the lease prior. So it's to allow for changes through time, basically in statutes or legal language.
From a efficiency standpoint, once I spend the time negotiating a lease once, and one of the reasons I look for very long terms, because I have the blessing of having a client that wants very long terms and very static uses, I don't want to have to renegotiate. I don't want to have to do that if there's a renewal coming up. We've done a renegotiation. We've gone through the various layers to do that. And although the last one was my first negotiation with DSL and everyone was delightful, I'd like to put that off as long as possible, just as a matter of principle, not because of anything that happened or because of how the deal came out. I understand that if state law changes, sure, all bets are off. But just because some DOJ lawyers got a little bit smarter or decided to do something a little bit different, for me is not a reason to renegotiate.
Okay, that is understandable. Chris or Sheena, do you want to weigh in at all?
This was language that we picked up from another program in our agency. And it was kind of one of those things where they had already kind of worked through the issues of a truncated renewal process, which is what we're trying to do here. And that's kind of where we got this from. So I think you have a very valid point. And honestly, we like long-term leases as well. So I think maybe that's something that we need to discuss and perhaps maybe reword this a little bit.
We'll highlight it and put a question mark by it.
Yeah, I've got your notes, John. It's definitely something we'll discuss. I don't know if we can.
I'd be curious if the rest of the non-DSL people are of similar thought as I am, or if anyone else would weigh in on and if I'm on an island here. And if I'm on an island here, then I'll eat it, and in 5 years we'll talk again. But if I'm not, I'd kind of like to know that.
Oh, good point, John.
I'm referring to the line in 9C, the second full sentence. As a condition of renewal, the department shall have the right to require amendment to the terms and the conditions of the lease at time of renewal.
And I think that Chip was chiming in to agree potentially while you were answering Stephanie's question.
Yeah, thanks, Chris. And John, you're right on the money, just given that, like with the carriers, wireless carriers, we go for either a 10-year initial term for additional 5-year renewal terms, which could be automatic, or any variation there. But we usually look at 25 to 30-year leases. And to get an end of an initial term, if you will, to turn around and then look for a renewal and then renegotiate at that point. For us on this side, it'd be literally, 4 new potential renegotiation periods through those renewal terms. So I think it needs to be cleaned up a little bit, just in clarity and what's the desire of the state, to do a renegotiation at certain points in order to move forward with that renewal term. And I just said just in the sense that a lot of these sites, communication sites, can easily, well, for example, Highway 78, multi-millions of dollars and in a large way. And so to go through and say it's a 5-year initial and then there's a renewal term, and that renewal term's for 5 years and it proceeds for additional renewal terms, go back and renew that is just it's a real big challenge. And with the thought that if you don't come to terms, that is there anything in the lease? I don't know. I haven't seen the boilerplate that could actually nullify the deal, and the carrier's out and has to dismantle. It's just a thought.
So, Chip, just to let you know, just to let you all know that just a peek beneath the hood here, later on in general terms and conditions, we do talk about the term of these leases being 10-year leases with a renewal period. So we are, under these rules, we would be doing longer lease terms anyways.
Yeah, so the question though, Sheena, is if we keep this sentence, are we allowed to change the terms and conditions? And then
yeah,
does that become a deal breaker for the lessee?
Yeah, and I can totally understand why that would. And I think we need to do some homework within our group to find out where that came from and what the rationale is behind it. And I'm open to rewording that or taking it out somehow, depending on what we find out internally.
Yep.
Yeah. I think we need to
Agreed.
find out if it's an agency policy or not.
Yeah.
So good eye, both John and Chip. We appreciate your input on that. And it is really highlighted on our note taking sheet. So
I would also make the argument if I was up for 5 years in 5 years, 5 years, 10 years, whatever the current lease term is with OPB, that this provision wasn't in effect when my lease was signed, so that it didn't apply. But I think it's bad from a policy perspective in that it causes a huge jump in transaction costs for both sides. Now, for me, that's a huge jump that I take one time at the renewal, but for the Department of State Lands, that's with every one of your renewals.
Yeah.
I don't know how many you do in a year, but that's got to be a significant body count requirement there. And just by that provision alone, to have to reopen all those leases, renegotiate them. So I think it's a bad provision, and to the extent that we could strike it or at least limit it to only those concerns that are that the DSL feels are really catastrophic, a law change, something like that.
very helpful. Thank you. Amber, you ready to take us into 10?
Yes, okay. So 10, if the department approves the application, the department will notify the applicant in writing of A, the amount of compensation pursuant these rules that the applicant must remit to the department to obtain the authorization. B, any insurance or surety bond or other financial instrument required by the department pursuant the requirements of these rules. And C, a draft copy of the lease. So it looks like we have an extra and. Is there any comments on the note?
I would rephrase A. It looks like a shakedown, the way it reads. The amount you're going to have to pay to get your authorization. What you really mean is the amount of your lease payment or your compensation.
So not to obtain the authorization.
Yeah, we've looked at your application. We've decided it's going to cost you X to get your authorization. I'm not sure I'd phrase it that way for the public.
So you're saying strike kind of that last part of the statement?
Yeah, your reference to the regulation down below is sufficient.
Yep.
Yep, I agree. I've got it crossed out.
No mob terminology.
Okay. So 11, the department will not grant a lease to an applicant until it has received all fees and compensation specified in these rules and evidence of any required insurance, surety bond, or other financial instrument. And the terms and conditions of the rules have been met. And that's kind of standard in all of our rules.
I think this is an issue we actually ran up against, and because I think the Department of State Lands is
yes,
normal course of business is to get payment before a lease is signed, and I think that's odd.
So we actually had a discussion with another part of the agency about this, and it's been an agency policy to do all of our leases in this way. So we also manage waterway leases under a different set of rules. And one of the examples they provided was, if you went to rent like an office space or an apartment or something of that nature, you would be hard pressed to find any type of lease that didn't require a deposit and a payment and things like that to get the lease in place. So that was one example that was used. Outside of it, it really has always been DSL's policy.
It's been years since I've leased a place, but I remember handing the check at the same time I signed the lease. So my issue here is I'm not giving someone a check, even if it is a very reputable agency like Department of State Lands, just on principle. I'm not giving someone a check and then trusting we're going to sign the lease.
And
the lease and the check, it should happen at the same time, or ideally within net 15 or net 30.
Sure. So there was another suggestion too, that if this was really a contentious issue, that we always had the option of going through like an escrow company where those types of things are handled, where one doesn't get the lease until the other's got the payment type of situation. So that seems more complicated than it has to be, but that was one suggestion that was provided.
We could draft some language in there that kind of says that, using an escrow company would be an option. It would depend on, we would then run into the issue of who pays for those services, but.
And John, I am noting your comments. So these are things we'll continue to discuss.
Well, let me ask this question. How often does the Department of State Lands get stiffed after a lease is signed on the first payment?
Often. Well, we don't work that way, but we definitely deal with people that don't pay rent on time, or don't pay rent on time quite frequently.
But they miss the very first payment after they've signed the lease?
Yeah, sometimes it does take a fair amount of time for them to send the checks they'll sign the lease and then they'll send us the lease document, but without a payment.
Well, what if the lease document had a provision that said that you're unable to do any installation until you've paid your otherwise you're out the transaction cost, which you would have been out if they didn't before the lease got signed anyways. There's no change there, right? But it strikes me that to protect the Department of State Lands, we need to make sure that there's no active use of the site until that lease is signed and payment is received.
Yes.
Yeah.
If they just renege on it.
That was helpful, John. We actually batted this one around even earlier today. because it stood out to us a couple of times. So we'll take
I
a
suspect
stab
the only
at that.
people that really challenge this are lessees that actually have lawyers.
No, actually, it's the federal government. That's actually the biggest
Can't
one
help
we
you
have
there.
problems with on this.
They have solicitors instead of attorneys.
Yeah.
Yeah, it also puts us in a position of having to regulate that, you know, making sure that they haven't done anything at the site as well. So when we get everything up front, you know, DSL isn't in a position of babysitting at that point.
I can respect that. I can see that. I can as soon as you're done with all your requirements, then you can go, and not before then. There's no legal right to start before then. I can understand that as a rationale. It seems like we could find a way to do that so that lease still precedes the check.
Mm-hmm.
Would you
And
be willing
that's what
to propose some language on that section, John? Just to propose, just to get the creative ideas flowing to maybe address this?
So 11.
Yeah.
Mhm.
And I do want to note that it's almost 5 o'clock and we have one left to go, but if you can submit us, like just send me an email with some proposed language. I'll include it in the summary for everything we've gone over today so that the whole group can see it. And then once we send out the meeting notes, we'll include any revisions we've made and track changes so everybody can see all the new proposals that have come from these comments.
So we need to wrap this up.
Yep. Thank you, Amber. Did you want to read 12 real quick then and we can be done?
Yep. So in addition to the provisions of these rules, a communication site facilities authorization issued by the department may not be valid until the holder has received all other approvals required by the department, such as a removal fill permit and any other applicable local, state, and federal governing bodies to use the state-owned land in the manner requested, unless otherwise determined by the director. So if you need a removal fill permit or you need a conditional use permit from the county, it might be that your authorization is not valid until you've proven that you've gotten those other required permits. Cassie, I see your comment, and yes, we can send you a new version of this document.
Yeah, we will go, it'll go out as part of the meeting minutes and all the preparatory stuff for the next meeting.
And then just real quick, number 13, the director may refer any application to the land board for review and approval. We typically save that for very, very controversial things. For these communication sites, we don't have to have land board approval, but there's some cases where it's controversial enough that we do want to take it to the state land board.
All right. Thank you very much, Amber and Sheena, both for leading us through that. And actually, look at that. We're right on time. I appreciate everybody holding all the way through till 5. Notice that the next meeting is set for September 14th. So between now and then, you can expect to see, again, the meeting notes, which we'll figure out how to call out items that may require input to determine if we have a consensus or not, and then how to call out just the items that are edits. So with that, as soon as I'm done talking here, we'll stop recording. But I appreciate everybody's input and participation, and learned a couple of things over on this side. We don't often use Zoom, so I learned a couple of things that should make it go smoother next time. So I'll try to have an extra monitor so I can be more diligent about keeping up on the chat. I appreciate Amber and Sheena noticing those popping up when I didn't see them. So we'll get better and better at this. Again, we appreciate everybody's input and expect to hear from us very soon.
Thank you.
Will the chat survive? Will the chat survive, be part of the public record?
The chat will be actually, we'll try to include a transcription of it with the notes.
Oh, I'm not too concerned about it. I was just curious.
Oh.
Just make sure you don't lose my last comment because I did your language there.
Yeah, so the chat itself does not become part of the recording of the meeting, but we can save and print the chat and build it into our notes. So So we have the ability to do that.
That's up to you. I just want to make sure you didn't
Yep.
lose the language I just gave you.
Yep.
You're looking for.
I've
Yeah,
copied it out.
thanks for doing that so
Amber.
quickly too, John. And John, I want to thank you for the extra, not just the perspective from the communication side, but from the regulation reader guy side. So thanks for your sharp eyes on that. Appreciate that. With that, everybody take care. We're going to go ahead and terminate the meeting, stop recording it. And Lonnie and Aaron, thank you again for your support behind the scenes.
Thank you.
Thanks, everybody.
Thank you, everybody.